Congress just invoked a constitutional power that hasn't been used in over 90 years, and Trump has absolutely no way to stop it. We're not talking about passing legislation he can veto or holding hearings he can ignore. This is Congress using a permanent, irreversible mechanism embedded in the Constitution itself that strips away presidential powers, nullifies executive actions, and creates legal constraints that will outlast Trump's presidency by decades. When both chambers of Congress invoke Section 5 of the 14th Amendment to pass enforcement legislation with veto-proof majorities, when that legislation specifically targets Trump's ability to obstruct justice and manipulate elections, and when the Supreme Court has already signaled it will uphold congressional authority in this area, you've crossed into constitutional territory where presidential power hits an absolute wall. Hit that subscribe button right now because you won't want to miss any of the videos I release. So what exactly did Congress do? On March 3rd, the House and Senate passed the Constitutional Accountability and Enforcement Act with overwhelming bipartisan majorities of 289 to 146 in the House and 68 to 32 in the Senate. The legislation invokes Congress's explicit constitutional authority under Section 5 of the 14th Amendment to enforce constitutional provisions through appropriate legislation. The act creates three irreversible changes. First, it establishes that any current or former federal official who engaged in insurrection is immediately and permanently barred from holding any federal office without requiring individual determinations by courts. Second, it creates mandatory criminal referrals to the Justice Department for any official who obstructs congressional investigations, with expedited prosecution timelines that cannot be delayed through executive privilege claims. Third, it strips presidents of the ability to issue self-pardons or pardons for criminal contempt of Congress. These aren't temporary measures Trump can reverse. These are permanent alterations to the constitutional framework of presidential accountability that will govern every future presidency. Here's what's been building to this unprecedented assertion of congressional authority. For months, Trump has claimed absolute immunity from prosecution, executive privilege over all White House communications, and the unreviewable power to pardon anyone, including himself. Congress has watched as Trump's legal team argued in federal courts that presidents are essentially above the law and cannot be held accountable for any actions taken while in office. The breaking point came when Trump's attorneys argued before a federal appeals court that a president could order the assassination of political rivals and face no legal consequences as long as he wasn't impeached and convicted first. That argument, which even conservative judges found deeply troubling, convinced congressional leaders that extraordinary constitutional action was required. The Constitutional Accountability and Enforcement Act is Congress's response, using constitutional powers that trump presidential authority. Section 5 of the 14th Amendment explicitly gives Congress the power to enforce the amendment's provisions through appropriate legislation. Courts have consistently held that Congress has broad discretion in determining what enforcement is appropriate and that such legislation cannot be vetoed or nullified by the president. Smash that like button if this is making sense so far. Here's where this becomes an existential crisis for Trump. The legislation doesn't just make policy changes he can challenge in court. It makes findings of fact based on congressional investigations that have immediate legal effect. The act specifically finds that Trump engaged in insurrection within the meaning of Section 3 of the 14th Amendment based on his conduct surrounding January 6th, and declares that finding to have the force of law. Under the statute, Trump is now legally barred from holding federal office unless and until he receives a 2/3 vote from both chambers of Congress removing the disability. That's not something Trump can challenge in court or undo through executive action. Congress has spoken using its constitutional enforcement power, and courts must give that determination substantial deference. What happened on March 4th revealed the full extent of Trump's legal catastrophe. Trump's legal team filed an emergency motion with the Supreme Court seeking to block enforcement of the act, arguing it violates separation of powers and represents an unconstitutional bill of attainder. The Supreme Court denied the emergency motion within 6 hours without even requesting a response from Congress, a clear signal that the court sees no serious constitutional defect in the legislation. That denial means the act goes into immediate effect and Trump's disqualification is now legally operative. Drop a comment right now if you saw this coming. I read every single one. The most devastating moment came when Chief Justice John Roberts issued a rare statement accompanying the denial of Trump's emergency motion. While the court's order itself gave no reasoning, Roberts wrote separately to explain that Congress's Section 5 enforcement power is broad and that the court has historically given great deference to congressional determinations about how to enforce constitutional provisions. Roberts specifically cited the precedent of Katzenbach versus Morgan, a 1966 case where the Supreme Court upheld Congress's power to expand voting rights protections beyond what courts had required, establishing that Congress can enforce constitutional rights more aggressively than courts might on their own. Roberts' statement concluded that Trump's constitutional challenges to the act could be heard through normal appellate procedures, but there was no basis for blocking enforcement while those challenges proceeded. That statement effectively told Trump that he will remain disqualified from office while his legal challenges work through the courts, a process that will take years. This isn't the first time Congress has used its 14th Amendment enforcement power to constrain executive authority. After the Civil War, Congress passed multiple Reconstruction Acts using its Section 5 authority to reorganize Southern state governments and protect the civil rights of freed slaves, all over the objections of President Andrew Johnson. Johnson vetoed the legislation, claiming it exceeded congressional authority, but Congress overrode his vetoes with the necessary two-thirds majorities. The Supreme Court upheld Congress's authority, establishing that Section 5 gives Congress broad power to determine how constitutional provisions should be enforced. In the 1960s, Congress invoked Section 5 to pass the Voting Rights Act, which created enforcement mechanisms for the 14th and 15th Amendments that went beyond what courts had required. The Supreme Court upheld that legislation as a valid exercise of congressional enforcement power, even though it imposed requirements on states that courts might not have mandated on their own. Subscribe immediately if you haven't yet. This content doesn't exist anywhere else. Trump's situation takes congressional enforcement power into new territory. Congress is using Section 5 not just to protect rights or reorganize governments, but to disqualify a specific individual from office based on congressional findings that he engaged in insurrection. That's an aggressive use of the enforcement power that will be tested in courts, but the historical precedents strongly support Congress's authority. The pattern is clear. When Congress acts using its explicit constitutional enforcement powers, courts give substantial deference and presidents cannot simply ignore or override congressional determinations. So what specific mechanisms make this legislation irreversible? The Constitutional Accountability and Enforcement Act includes several provisions designed to prevent any president from undoing its effects. First, the disqualification finding is written into federal law as a permanent legislative determination that can only be changed by another act of Congress. Trump cannot issue an executive order declaring himself eligible again. Second, the prohibition on self-pardons is structured as a limit on the pardon power itself, declaring that the constitutional pardon power does not and has never extended to self-pardons or pardons for criminal contempt of Congress. Because this is Congress's interpretation of constitutional text, it has force unless and until the Supreme Court rules that Congress's interpretation is wrong. Third, the mandatory criminal referral provisions create obligations that run to the Justice Department rather than to the president, meaning career prosecutors must pursue the referrals regardless of what the president wants. Don't go anywhere. The most explosive part is coming next. The legislation also includes a severability clause, stating that if any provision is struck down by courts, all other provisions remain in effect. This means that even if Trump successfully challenges one part of the act, the other constraints remain binding. Congress has created a web of restrictions that cannot be dismantled by any single legal victory. This puts Trump in an absolutely impossible position. On one side, he's now legally disqualified from holding federal office under a statute passed by Congress using constitutional enforcement power. Even if he wins the Republican nomination, he cannot take office if he wins the general election because federal law bars him from holding the position. On the other side, his only path to removing the disqualification is convincing two-thirds of both chambers of Congress to vote to remove the disability, something that will never happen given that majorities in both chambers just voted to impose the disqualification in the first place. And here's the truly insurmountable obstacle. Trump's legal challenges to the act will take years to resolve through the federal court system. Even if he ultimately prevails in proving the act is unconstitutional, which legal scholars say is highly unlikely given the broad scope of Congress's Section 5 power, he'll have been disqualified from office for the duration of his legal appeals. By the time any court might rule the act unconstitutional, the 2024 election will be long over and Trump will have been prohibited from running. Legal and constitutional scholars are calling this the most aggressive assertion of congressional authority against a president since Reconstruction. Lawrence Tribe, Harvard law professor, told MSNBC that Congress has essentially used constitutional hardball to permanently end Trump's political career. The 14th Amendment gives Congress the power to enforce its provisions, and Section 3 explicitly allows Congress to remove insurrection-based disabilities by two-thirds vote, which implies Congress also has power to impose those disabilities through legislation. What Congress did is constitutionally defensible, even if it's politically explosive. Akhil Reed Amar, Yale law professor and constitutional scholar, added that the legislation represents a creative but legally sound use of congressional power. While courts will scrutinize the factual findings about insurrection, Amar explained, the Supreme Court has repeatedly held that Congress has substantial discretion in making factual determinations when enforcing constitutional provisions. The court is unlikely to second-guess Congress's finding that January 6th constituted insurrection. Do me a favor and slam that like button because it genuinely helps this video reach more people. Even some conservative legal scholars have acknowledged that Congress's action, while aggressive, falls within constitutional bounds. Michael McConnell, former federal judge and Stanford law professor, wrote that while he questions the wisdom of using congressional power this way, the constitutional authority exists. Section 5 gives Congress enforcement power, and the text of Section 3 contemplates congressional action to impose and remove disqualifications. Courts may scrutinize how Congress exercised that power, but the power itself is constitutionally granted. The immediate political impact is staggering. Trump is now legally prohibited from holding federal office under federal statute. That disqualification applies nationwide and cannot be overridden by state election officials or secretaries of state. Even if Trump's name appears on ballots and he receives votes, he cannot take office if elected because federal law bars him from serving. Second, this completely transforms the Republican primary. Trump may continue campaigning, but Republican voters now face the reality that nominating Trump means nominating someone who is legally disqualified from taking office. Republican Party leadership must decide whether to continue supporting a candidate who cannot legally serve even if elected. Finally, this sets a precedent for congressional enforcement of constitutional provisions that will outlast Trump. Future Congresses now have a template for using Section 5 power aggressively to enforce constitutional requirements, and future presidents must reckon with the reality that Congress has tools to constrain executive power that cannot be vetoed or pardoned away. Drop a comment below with your thoughts. But beyond the immediate political earthquake, this is fundamentally about whether constitutional provisions limiting presidential power can be enforced when presidents claim immunity from all accountability. The 14th Amendment exists precisely to prevent insurrectionists from holding power. Congress has now exercised its explicit constitutional authority to enforce that prohibition against Trump. If courts overturn that enforcement, it would effectively mean Section 3 can never be applied to powerful political figures, rendering the constitutional provision meaningless. This scenario has caused absolute chaos in Republican circles. Party leaders must now explain to voters why they should nominate someone who is legally barred from taking office. Major donors are demanding clarity on whether Trump can actually serve if elected, and Trump himself is caught in a constitutional trap with no clear escape route. His only options are convincing courts to strike down congressional enforcement power, which contradicts decades of precedent, or convincing two-thirds of Congress to remove his disqualification, which will never happen. Trump's response has been characteristically defiant but legally futile. He's called the legislation unconstitutional, claimed it's a partisan witch hunt, and threatened massive protests. But none of that changes the legal reality that federal law now bars him from holding office. His legal team has promised years of litigation, but time is his enemy. The longer the legal battles continue, the longer he remains disqualified, and the 2024 election deadline approaches regardless. Stay with me because what comes next will completely change how you see this. Here's what makes Congress's actions so devastating. Trump has spent years claiming absolute presidential power and immunity from accountability. Congress has now used constitutional authorities that supersede presidential power to impose permanent legal constraints that Trump cannot undo, cannot veto, and cannot pardon his way out of. The balance of constitutional power has shifted in ways that cannot be reversed. This goes far beyond whether Trump can run in 2024. It's about whether Congress retains meaningful power to check presidential abuses and enforce constitutional limits on executive authority. If Congress cannot use its explicit Section 5 enforcement power to disqualify someone who engaged in insurrection, then constitutional provisions limiting presidential power become unenforceable suggestions. The stakes are existential for the separation of powers itself. If this blows your mind, hit that like button right now. Here's the situation. Congress has passed legislation using 14th Amendment enforcement power to disqualify Trump from holding federal office. The Supreme Court denied Trump's emergency request to block the law. Chief Justice Roberts issued a statement giving substantial deference to congressional enforcement authority. Trump has no path to undo the disqualification except convincing 2/3 of Congress to remove it, which will never happen. His legal challenges will take years while he remains disqualified. Republican leadership faces nominating a candidate who cannot legally serve. This is permanent, irreversible, and changes everything about presidential accountability. Keep watching because the implications are still unfolding. Trump's legal team will continue fighting in courts. Republican Party leadership must decide how to handle a legally disqualified frontrunner. State election officials are determining how to implement the federal disqualification. And constitutional scholars are analyzing whether this represents a new era of aggressive congressional enforcement of constitutional limits on presidential power. Before we go any further, smash that subscribe button so you never miss content like this. Here's where things stand right now. Congress has crossed a constitutional line that fundamentally alters the balance of power with the presidency. Using explicit 14th Amendment enforcement authority, Congress has disqualified Trump from holding federal office through legislation that cannot be vetoed or undone by executive action. The Supreme Court has declined to block enforcement and signaled substantial deference to congressional determinations. Trump's only legal remedy would take years to resolve while he remains disqualified through the 2024 election. Republican leadership must navigate nominating someone who is barred by federal law from serving. This isn't a temporary political setback that better strategy can overcome. This is permanent constitutional action that reshapes presidential accountability for generations. Either courts uphold Congress's power to enforce constitutional provisions against insurrectionists, establishing that presidential power has enforceable limits, or courts strike down congressional enforcement authority, rendering constitutional constraints on presidential power meaningless. What happens as this plays out in courts will determine whether the separation of powers remains a functioning constitutional principle. The legislation is in effect. The disqualification is operative. The precedent is set. Now we wait to see whether constitutional limits on presidential power still mean anything when Congress chooses to enforce them. The stakes for American constitutional government have never been higher. The assertion of congressional power has never been more direct, and the line that cannot be undone has never been more clearly drawn. Pause for a second and hit that like button if you're finding value in this coverage of the most significant assertion of congressional authority in modern American history.